From SANCCOB, from BirdLife South Africa, the Green Connection, I believe Natural Justice is here as well, and all our esteemed guests that are watching our committee meeting online. It's my honor to welcome you all to today's sitting. It's our first sitting of our Select Committee on Public Infrastructure and Minister in the Presidency. And today we will be considering joint oral submissions on the marine oil pollution, the Preparedness, Response and Cooperation Bill, Bill B10 of 2022. It's one of our bills that we revived from the 6th Parliament. This bill represents a critical step forward in strengthening South Africa's preparedness and response mechanisms to marine oil pollution, ensuring alignment with international environmental protection obligations and the rights enshrined in our Constitution. Marine oil pollution is not only an environmental concern, it's also economic, social, and legal imperative. The destruction of marine habitats, the violation of environmental rights, and the significant threats to livelihoods, particularly those dependent on the ocean economy, demand decisive legislative action, as outlined in the International Convention on Oil Pollution Preparedness, Response and Cooperation, the OPRC, to which South Africa is a party. We have a duty to ensure that our legislative framework adequately provides for prevention, response and accountability in cases of marine oil pollution. So today we'll hear joint oral submissions from key environmental and conservation organizations, including Biodiversity Law, the Biodiversity Law Centre, SANCCOB, BirdLife South Africa, the Green Connection and Natural Justice. Their perspectives and expertise will be invaluable as we assess how the bill ensures community participation, environmental justice and compliance with global standards. Following this, we will receive a response from the Department of Transport on both the oral and written submissions, ensuring that stakeholder concerns are addressed and the bill achieves its intended objectives effectively. As a nation with over 3,000 kilometers of coastline and direct jurisdiction over a vast ocean territory, our responsibility extends beyond our borders. The interconnected nature of marine ecosystems necessitates strong cooperative governance, adherence to international best practices, and the inclusion of impacted communities in decision-making processes. This committee has a critical role in ensuring that the bill provides clarity, enforceability, and the necessary institutional capacity to prevent and respond to oil spills efficiently. We must ensure that the legislation does not merely exist on paper, but translates into practical, well-funded, and well-coordinated action. As we proceed, I urge all participants to engage constructively, keeping in mind our collective responsibility to safeguard our marine resources for current and future generations. So with that, I'd like to open today's proceedings officially with introductions. If I can start with the introductions of the members of the National Council of Province of the Select Committee, Infrastructure and Minister in the Presidency. If you can just introduce yourselves, please.
Good morning, Chairperson. Good morning, colleagues and all of our guests. My name is Tammy Briet. I am an NCOP member from the Free State.
Thank you.
Good morning, Chair, honorable members and all officials. I'm Olis Kaunda, permanent delegate from KwaZulu-Natal. Thank you.
Thank you.
Good morning, members. I'm Mandisa Makesinu, permanent delegate from Free State. Thank you.
Thank you.
Morning, Chair and honorable members. My name is Jablan Wakanzimande, permanent delegate from Gauteng.
Good morning, members. My name is Manza Peter. I'm a permanent delegate representing Eastern Cape. Thank you.
Thank you very much. Can we then have the introductions from the Department of Transport, please?
Good morning, Honorable Chair. It's good to see you once again, and esteemed members. My name is Mchunzi Madia, the DDG responsible for maritime transport in the Department of Transport.
Is your mic on? There we go.
Yes, now it's on. Yeah. Thank you. Sorry for that. Yeah. Good morning, Chairperson, honorable members. My name is Dumsane Ntuli and I'm the Chief Director responsible for maritime transport policy and legislation.
Thank you.
Morning, Chairperson and honourable members. I'm Nicholas Leonsinis, the Parliamentary Officer for the Minister in the Department of Transport.
Thank you very much. Anyone else from the department? No? And then our stakeholders present today. Can I ask Ms. Brody if you want to introduce the stakeholders? Thank you. I'm sure they can do it themselves, but if you want to start.
Good morning, Chair. Good morning, honourable members and representatives from the Department of Transport. We are extraordinarily privileged to be here today and have the opportunity to answer your questions around our submissions. My name is Nina Brody. I am a senior attorney at the Biodiversity Law Centre. We have a particular mandate to ensure that biodiversity is looked after and that we make connections between ensuring ecological health and the livelihoods of the people of South Africa. We also operate regionally, so we do have an interest in making sure that we connect with the rest of our region and the world. And in terms of our presentation today, I will be leading the primary presentation, and then my colleagues will take over from me. Let me just introduce them. So I'm going to horribly embarrass my colleague Monica Stassen, who is welcome to come through to the front. She, once she's caught her breath, will introduce the work of SANCCOB. She is a representative from SANCCOB. We also have Ms. Christina Hagen, who is sitting behind me. She is from BirdLife and will give you a short one-liner on what BirdLife does. Christina has particular expertise in sitting on some of the technical working groups within the Department of Forestry, Fisheries and the Environment and working from that perspective. We also have my colleague who is behind me, Alan Basajasubi, who is from Natural Justice. His expertise is in relation to the public participation elements. His colleague, Andres Maman, is sitting also behind me, and he is working with Alan and the West Coast communities, which is where he is from. We also have with us colleagues from Green Connection. We have Lisa Makahula opposite me, who will assist Alan in answering your questions about communities. And then I'm not sure we've got where Chris has gone to, but we have Chris and Liziwe who are here as well. If you have any questions after the presentation, I'm sure they'll be happy to assist. So I'm just going to hand over to my colleagues briefly just to give you a little bit of a one-liner on what their organizations do. So perhaps, Alan, you would like to start?
Thank you, Chair. Honourable members. So I work for a civil society organization known as Natural Justice, and our primary mandate is to represent the interests and legal rights of communities, particularly in the context of the environment. And we also ensure that the environment and its integrity is protected and promoted. We have an office based in South Africa, Cape Town, but we also have regional offices in East Africa, Kenya, and West Africa, Senegal. So we really try to approach the protection of human rights from environment at a regional level, but more specifically here in the African context. So I'll hand over to my colleague, Christina.
Thanks very much, Chairman and honourable members. So BirdLife South Africa is a registered non-profit organisation, and our mission is to conserve birds and their habitats through scientifically based programs and with a focus on the sustainable and equitable use of natural resources. We have a very strong seabird focus, particularly on African penguins, and we have been involved in the sort of ship-to-ship bunkering and marine oil and noise pollution space most recently. Thank you.
Hi everyone, my name is Lisa Makaula from the organization called the Green Connection, and I think my colleagues as well have introduced themselves. Liziwe McDade, who is our strategic lead, and Christopher Scholes, who is our parliamentary liaison person. The Green Connection is an eco-justice organization that promotes good governance, and we work with coastal communities, which today we will be highlighting mostly in terms of if there are questions directed in terms of how communities, particularly the small-scale fishers, how they are impacted when there happens to be an oil spill. We are happy and ready to answer those questions, but we basically work to promote good governance and to ensure that the rights of the coastal communities and their livelihoods are taken into consideration. Thank you so much.
Thank you. And then my committee staff, on my left-hand side, your right-hand side is Mr. Mtelini, he's our committee secretary. And we've got Dr. Anneke Clark, she's our chief cook and bottle, she's our committee advisor and researcher. And then Zoliswa is here somewhere. And who did I miss? Is anybody who hasn't introduced themselves, just so we know who you are? Oh, our legal advisors. Where are they? Introduce yourselves so we can acknowledge you.
Good morning, Chairperson and the colleagues and honorable members. My name is Andile Tejana, and I'm from the Constitutional and Legal Services Office. Thanks.
Thank you.
Greetings, Chairperson and honorable members and everyone. My name is Phumelele Ngema, also the Parliamentary Legal Advisor.
Thank you very much.
Good morning, Chairperson and honorable members. My name is Baba Alwatoise from the Office of the Chief State Law Advisor.
Thank you. Very welcome. Thank you very much for that. Mr. Mtelini, any apologies?
Thank you, Chairperson. Good morning, honorable members, colleagues, and everyone present today. We have received following apologies. We have received apology from Honorable Meimang, Honorable Skerkochel, and Honorable Mabebo, and Honorable Mulokome. Thank you, Chairperson.
Thank you very much. So we do have a quorum. Right, so what we'll do now is the program has been distributed. We'll go through the joint oral submissions. That'll take us to roughly 10:35. And then I was hoping to give you 5 minutes extra, but everybody's done long introductions. 10:35. Then we'll do questions for clarification on your submissions from the members of the National Council of Provinces. The department's response will then follow. It'll take us from 11 to 11:45. And then there'll be some deliberations on the department's responses, which will then take us to 12:15, where we'll just have a quick homework to do. We're adopting the minutes of the previous meeting we had last year, and then we'll close the meeting, hopefully by 12:35, if everything goes according to plan. So without further ado, please, Ms. Brody, you're welcome to continue. And if, Monica, the Department of Transport's DDG is here if you want to make comments about the traffic on the West Coast Road. You're welcome to chat to him afterwards. Okay, please start.
Thank you so much, Chair. So our submissions our oral submissions today, we're not going to go through every detail of the written submissions that we've made. We are rather going to focus on giving you a broad overview of the background to our submissions and the principles informing them. And then we would welcome your questions, even if they are on the nitty-gritty of drafting. So in terms of the themes that we are covering, there are roughly 6 of them, as you will see on the screen. The first is around marine pollution, environmental rights, the environmental principles, and the obligations of the transport cluster. We are very mindful that transport does not operate in a bubble. The Department of Transport is only one piece of that puzzle. It has a lot to do, and the maritime sector is only part of that. And in this particular bill, as in all the other pieces of legislation that deal with international maritime organization work, it is often SAMSA, the South African Maritime Safety Authority, that is the designated authority, not the department itself. So in terms of ensuring that the relevant environmental rights, principles and obligations are sort of mainstream throughout all of this, which is what is required by the Constitution, that is what we are speaking to. Next, we understand that when this bill was introduced and in previous presentations, including I think from Dr. Clark, you were advised of the importance of domestication of this bill. We will only touch on that. We are also, in terms of our submissions, touching on the need to close legislative gaps and the need to ensure clear rights and duties, which is something that is really important with legislation, and we are hoping that we can engage with you to make sure that what comes out of this process makes it crystal clear to everybody who has to actually take action in terms of this litigation, what they need to do. Sorry, not litigation, legislation. You can see that I'm a lawyer, sorry. And then we also very much want to discuss with you ensuring integration between this bill and existing statutes, including those that actually sit within the environmental cluster. And the overarching statute there is the National Environmental Management Act, or NEMA, and as we'll discuss, that should pervade and definitely speak to this particular bill in our view. And then, of course, we cannot ignore the importance of community engagement, access to information, and active and meaningful participation. There is an incredible risk that when we are looking at the domestication of international instruments, that we overlook the domestic imperatives around community engagement. And that is one of the reasons why we want to highlight that now. Even though all of us do not want to hold up the domestication of OPREC, we do feel that it's very, very important that these considerations are written into your thinking. And if there is a way to ensure that the bill is passed by taking account of them, we would certainly urge you to do so. And then finally, we are ending off with a plea to you on a number of next steps beyond this bill and suggestions as to where you and our colleagues in the Department of Transport can potentially really ensure that transport and environment speak to each other. So that is by way of introducing our approach. Then, just as a reminder, this definition that you see on the screen of pollution is one that is found inside the National Environmental Management Act. Because NEMA is framework legislation, that definition is the one that should be pulled through to all our legislation that deals with pollution. And that includes specific legislation such as this one, which deals with a specific type of pollution. You will note there that the types of pollution that the definition contemplates are substances, so that's where oil, hazardous substances and so on fit in, but also radioactive and other waves, noise, odors, dust, or heat. And we will come to some of the gaps which affect noise in particular. That is something that has been highlighted in the ocean space. And we are aware that both this committee and its counterpart in the National Assembly have been had presentations around noise, marine noise pollution, and one of our queries to you is how can we work together to find a home for that regulation, but we'll come to that at the end. In terms of the rights that are affected, primarily what is invoked is Section 24B of the Constitution, which deals with everyone's right to have the environment protected for the benefit of present and future generations. There are various mechanisms or measures that need to be implemented to give effect to that right, one of which is legislation, and that is where Parliament's role is paramount. And there are the three subclauses that sit in Section 24B, and the first of those is the obligation to prevent pollution and ecological degradation. So this fits very firmly there, but it's not to forget the other parts of that right, which address the need to promote conservation and also to secure ecologically sustainable development, while also ensuring that economic and social development is justified. And that is a very important understanding of the right to development as written into our Constitution. And the right to development becomes critical in terms of livelihood rights as they are understood in the African context, in terms of the African Charter on Human and People's Rights, but also in our law and through our courts. And so it doesn't stop at the environmental rights. The Section 24A, which is an environmental right, also addresses the need to protect everyone's health and well-being and to prevent it from being harmed through pollution and other sources. That has been upheld by the courts as a self-standing, immediately realizable right, and naturally oil pollution and other kinds of pollution immediately affect human health, in addition to the wildlife, where we're so familiar with those terrible pictures that we see every time there's a spill. But we also have very important rights in terms of cultural rights, rights of association, religious rights that are directly impacted by pollution events and which are often forgotten about. And that is something that during question time, perhaps Andres, Lisa, and Alan can speak to in terms of their experiences with that. And again, this is something that our courts have recognized, and it is also recognized within Africa and increasingly at an international level. We have an opportunity to lead the way in integrating all of this. That is by way of background, and it might seem a little bit remote from the job at hand, which is to domesticate this particular treaty. But what we're hoping to demonstrate to you is that it's not remote, and it isn't just by way of background, and it is integral to how we ought to consider our legislation, both this, and we are aware that the Department of Transport, well, we hope we've got this right, the Department of Transport is currently updating many of its pieces of legislation, and we would hope that this is also something that can inform their thinking. So we've put there that the state has a duty to prevent pollution, and we welcome transport taking these duties seriously. We really do. We have had incredibly positive engagements with the Transnet National Ports Authority. We've found that their attempts to mainstream environmental, biodiversity, and public participation concerns have been excellent. And we hope that that is an indication that transport as a whole is doing so. We also see it as incredibly helpful that there is this push to get these treaties domesticated. So these are reasons why we should align with international law. I think, Honourable Chair, you touched on some of them in your opening address, so I will not repeat that. But what I will touch on is in the central column, we've got one contributor to preventing pollution is adherence to the pollution controls agreed by the International Maritime Organization. We are a member, but we have lost our seat on the council. And it is quite important from a funding perspective, but also from the ability of South Africa to influence international policy in this space, that we get that seat back. And in order to demonstrate our sort of bona fides in that direction, we really do need to make sure that our internal framework matches the commitments we've made at international level. And that is why it is so important that this is domesticated. And we'll come to the principles. We listed some of those that are sort of more or less now debated as customary international law. But we'll address the principles in a moment. And then the two in red are the provisions in the Constitution that refer to international law. And regardless of what happens with the domestication or otherwise of a treaty like OPREC, we can't avoid it. We have ratified it. We are part of the IMO, and one way or another, it is going to influence how we do things. So to protect our sovereignty as a nation, it is really important that we domesticate it in a way that fits within our legislative framework. And that includes the fact that we have a particular kind of democracy in this country, that we have particular rights in this country. And it is absolutely critical that we bring all of this together so it's fit for our purposes. And again, that just summarizes the reasons on the screen. There are ecological, geographical, constitutional, financial, and moral reasons for ensuring alignment. Then this is a bit of a sketch map of the scheme that OPREC fits into. IMO has two sets of treaties, if you like. The one deals with safety issues, which is not what we're talking about today, and the other deals with anti-pollution measures. So in the world of anti-pollution measures, the so-called MARPOL Treaty is the primary maritime anti-pollution measure. You will be aware that the President recently signed into law the Marine Pollution it was, I have to always run this through my head, the marine pollution, it's the prevention of pollution bill. There are a number of marine pollution acts, and it's always, one needs to remember what goes in the brackets of those acts, and it can get incredibly confusing. But that has the reason why that was recently amended was to enable us to domesticate the most recent, well, two of the annexes that had not yet been domesticated, and the most important of those probably is the one dealing with greenhouse gases. It hasn't yet commenced. Once it commences and the President says we're good to go, then we will be totally aligned with MARPOL. But MARPOL needs support from other sort of pieces of this system. The treaties dealing with dumping of wastes and anti-fouling have actually not been expressly or clearly domesticated. The National Environmental Management Integrated Coastal Management Act does domesticate most of the treaty dealing with dumping of wastes, but in a slightly, it's a little bit difficult to understand sometimes. The regulations are not fully, they're not very clear. It's a little bit difficult to follow, but that does fall under, that it's landed up falling under the Department of Forestry, Fisheries and the Environment. The anti-fouling systems, there's provision made for regulations for that under the Merchant Shipping Act, but we haven't been able to find clear regs on that so far. And the Ballast Water Convention is actually a real problem in that there was a draft bill that was put into Parliament ages ago, and then it sort of fell off the map, and we don't have anything in place. And that is important because it's through ballast water that alien organisms are introduced into our waters, and that can have a catastrophic impact on aquaculture, on our fishing communities, and obviously the environment. But it's got a real a direct economic impact through what can be introduced. But where we are now is OPREC. And what this is about is making sure that we have everything in place in terms of oil pollution events so that we can meet our obligations under MARPOL. There is a protocol to OPREC which deals with hazardous substances, so the HNS. We, and our colleagues from Transport can correct me if I just haven't been able to locate it, but it seems that that hasn't yet filtered its way through the whole ratification process, and that is something to put on our radar. For the rest, intervention has been domesticated. That's about intervening in pollution events on high seas, so outside of our boundaries. The last two there deal with wrecks and salvage, and we've got sort of patchy legislation dealing with that. And then liability and compensation, I put it up there because it is under different legislation, but it is something that will come up today. So that is where we are. In terms of the process for domesticating the anti-pollution treaties, Section 231(2) of our Constitution, which 231 is the provision dealing with international law, that requires that both the NA and NCOP need to confirm ratification. That becomes important in terms of some of our comments on the bill around the need for cabinet approval of cooperation with neighboring states. Because any of our regional treaties will already have been signed or ratified by our executive function and ratified through a parliamentary process, it seems a little bit odd that our executive could then put a pin in cooperation where we've agreed to that under treaty law. So we have a few question marks about that, and that is the rationale for putting that up there. Then there is a process, particularly through a treaty such as OPREC, that requires that any country filters it through into their national framework, and that is where we're at now, and that is where Section 231 sub 4 comes into the picture. As I said a moment ago, historically the IMO treaties have been domesticated through various marine pollution acts which fall under this portfolio together with merchant shipping statutes. There is a merchant shipping amendment bill that is coming your way shortly, I understand. And then, of course, NMICMA, which falls to the Department of Forestry, Fisheries and the Environment. The difficulty with the marine pollution and merchant shipping statutes is that many of them predate our environmental management framework. So there is misalignment. They are outdated. Sometimes they're behind the times in terms of international things, just moving on. And so there is a need to pay attention to this and sort of bring everything into the 21st century. And that includes making sure that we are up to date in terms of how our society treats and values certain things, because most of them originate in the 80s or earlier. So you can see how that would be quite problematic in terms of the society we have today. And then, as I mentioned a little while ago, we are lagging a little bit in terms of the domestication of the IMO anti-pollution treaties, which is affecting our standing at the IMO, and that is having knock-on effects in terms of our ability to influence at an international level, obtain funding, and reap the benefits of being part of the IMO. And then South Africa does not properly regulate noise, and that is something that is definitely on the radar of the IMO, and they have given us quite a bit of money to be part of their project called the Glow Noise Project, of which many of you may be aware, which is to start looking at how to deal with noise regulation in the maritime space. In terms of the guiding principles that we have used in terms of putting our comments together, and that we would very much urge you to consider, cooperative governance is written into the Constitution. It is written into the Cooperative Governance Act. And it is also written into NEMA in terms of the concept of integrated environmental management. And it requires different organs of state to work together, both in terms of national, province, and local level, but also between departments and between organs. And that is something that we do think that this bill has the capacity to do, and there are areas where we think it could perhaps do it better. Participatory democracy is an important one. This is a critical aspect of the democratic society that is meant to be guided by our Constitution, and that is precisely why community participation, community voices, and public participation cannot be ignored, even when we are dealing with something that might seem that it is an industry and international matter. Then there is a principle at law, and as you will all be aware, once a statute is passed, it falls to the lawyers to figure this out. And so there are principles of statutory interpretation developed by our courts, which require that where there are statutes operating in the same place, they need to be harmonized. And somewhere where you as a parliamentary committee can help us make sure that we get at the end what you intended is to make sure that the language of this is as clear and as integrated with the language of other statutes as possible. That way you're not sitting looking at what the courts have come up with, scratching your heads and saying that's not what we intended. So it is at this stage that it is possible to try and get things as clear as possible. And no piece of legislation is ever perfect. That's why our courts are able to interpret statute, but that is why we've got that there. And then the environmental management principles. Section 2 of the National Environmental Management Act sets out a very widely cast set of principles that decision makers need to take into account when making decisions that materially affect the environment in South Africa. The 8 principles that we've highlighted there are things that also operate in the international domain. The precautionary principle is absolutely central to this particular bill, because what we are trying to do is to assess risk and prevent risk and make sure that there can then be, we sort of provide for the best preparation if something should go horribly wrong with our risk management. The precautionary principle is very closely tied to the notion of the best available science. This is actually written into the Marine Living Resources Act, and it comes from the overarching Law of the Sea Treaty, which is the United Nations Convention on the Law of the Sea. And in the maritime space, there's also reference to best available technology. And that is somewhere where we understand there are multiple players in the ship manufacturing space that would actually welcome legislation that gives them impetus to upgrade vessels. The polluter pays principle is also integral to this particular statute, and one of the things that we will perhaps get to address in question time is just how that plays out in this space. Some of our comments have addressed where this is effectively done or less effectively done in the bill as currently drafted. The prevention principle, like the precautionary principle, is absolutely central. And then both public participation and community-driven solutions are not the same, and it's important that we differentiate. Public participation is what's happening now. It is what happens when there's a notice and comment process. It is what happens during an environmental impact assessment. Community-driven solutions is where the knowledge and the wisdom and the practices of communities are those that guide how one should respond. And while this is a space where scientific and technology-driven steps are internationally recognized and really, in many ways, are paramount in terms of the international guidance, again, in our country, we definitely need to look to what our local communities, and particularly our coastal communities, can offer, and there is a lot that they can offer. The integration principle is pretty much what we've been talking about, that we bring all our laws together and we don't have everything all over the place. And then finally, we have intergenerational equity, which is written into Section 24B of the Constitution, which requires that we don't just make decisions for ourselves, but also for generations to come. I'm going to hand over to my colleague Alan, who is going to take us through this slide, and then we will, I think, wind up.
Thank you again, Chair and honourable members. Before I get into it, I just wanted to provide context, which is relevant to, I suppose, the concerns that have been raised by communities that we've been in discussion with. Most of you might know or might not know, early this year there was a sort of marine pollution spill that happened on the west coast, particularly around Strandfontein and Duranby. It was by the MV Ultra Galaxy ship. And as part of that, the outcomes of that, there was certain impacts that were felt by some of the communities. And in our deliberations with the communities, we thought this was the perfect opportunity in which we could see how we could integrate some of the concerns and perspectives of communities within the development of this bill. And so our intervention is really aimed at sort of emphasizing how we can integrate the perspectives of communities within the development of the bill. Some of the concerns raised were just around sort of the critical gaps in the existing mechanisms that deal with responding to spills. Many community members mentioned how the delayed coordination between agencies and government officials allowed, or not allowed, but rather resulted in a spill continuing on a continuous basis. And so for them, they communicated or wanted to raise the perspective that it is integral that their perspectives and their knowledge sort of be integrated within response times. So them participating in being able to relay information to various agencies and departments in order to speed up the time in which response is dealt with, given the fact that some of them are coastal fisher communities and engage in the environment quite extensively, and even some of them being located in the sea and often being able to quickly ascertain and see what kind of response is needed. So raising the perspective that, we need to address possible critical gaps in terms of how response is dealt with. And then they spoke about really the need to, as Nina mentioned, the integration of traditional ecological knowledge. Now, this is a global practice that is recognized across the globe, where there are instances where communities who form part of a marine environment, for example, possess long-standing historical knowledge of the marine environment, how it works, different marine species, and understanding the extent to which the impacts to that affect cascading down into not only the environment and ecosystem, but also people. And so it's widely recognized, and fundamentally enough, the Departmental Environment, Forestry and Fisheries is leading a charge of trying to see how we can integrate indigenous knowledge systems, which is essentially community of practice, and how that could be utilized together with scientific knowledge to perhaps respond to spill impacts and maybe assess the extent to which some of these impacts can be diverted, and perhaps to also ensure that there's a collaboration between communities who possess this knowledge in developing contingency plans that deal with responding to some of these spills. And so there was a very clear perspective that they would like to see some of this knowledge be integrated as part of developing contingency plans in order to ensure that it's robust and speaks to the interests and the rights of communities at the local level. Another aspect that they spoke about quite extensively was, at the moment, there seems to be a critical gap around a compensation mechanism, one that's transparent and accessible to communities, but also one that ensures that it's sort of available to impacted members of society, particularly coastal fisher communities and also coastal communities living close to where areas of spills might happen. We know that for some of the community members, fishing is their livelihood. And where an oil spill happens, and it happens after a prolonged period of time, that has cascading impacts on their livelihoods. And obviously that means loss of income and loss of opportunity to practice their livelihood. And then also with that, we know that there are some fisher groups who are on the seas, and if in any event are exposed to some of these pollutants, that has a direct impact on their health. And so one of the critical gaps or concerns that they've raised in discussions is the development of a mechanism that is accessible to them post-spill, but one that would still be managed by government, but having oversight and transparency in which communities could engage with directly and ensure that it's being managed in a way that reflects the rights of communities. And the last point, which Nina's already spoken to, is really just reinforcing and strengthening the legal principle of the polluter pays principle. And that really is just ensuring that corporations are held accountable for environmental damages, and that there are penalties that are imposed in ensuring that any damages that occur, really that direct relief is then released to communities, tourism workers, and other coastal communities that might particularly be impacted by that particular oil spill. And so fundamentally, those were the four concerns and perspectives that we thought would be best placed to try and engage with the members here and see how that could strengthen the bill going forward, so that we do not find ourselves in 2025 dealing with the consequences that a lot of the communities on the West Coast have to deal with, given the MV Ultra oil spill that happened on the West Coast. I'll now hand back to Nina to continue.
Thank you. Chair, I see we over time. I don't know if we can just wrap up quickly and then. Right. So we have, I'm going to skip through the next two slides of our recommendations, and perhaps we can rather engage in a discussion around that. And by way of wrapping up, we thought we put our heads together around certain things that this Parliament can perhaps help us with going forward. So firstly, there is the issue of domesticating outstanding treaties and promoting ratification of those where South Africa has not yet signed on the dotted line. Some of those fall to the transport portfolio, some do not. But there are some particularly important things that are outstanding. The Ballast Water Convention, we have ratified. It shouldn't be that difficult to either lobby or exercise oversight in terms of the Department of Transport to put regulations in place, alternatively, to ensure that a bill does, in fact, domesticate this. The agreement on port state measures has been ratified. It falls to the Environmental Department, but it does need to be integrated into legislation. And then there are a number of outstanding IMO treaties, as well as treaties with the Food and Agricultural Organization that impact on both transport and environment. Just to skip to the very last one, we've said ratify the United Nations Agreement on Marine Biodiversity of Areas Beyond National Jurisdiction. That's, the shorthand is either the BBNJ or the High Seas Treaties. That probably falls to the environment, but there is we are in the middle of the UN Oceans Decade, and there is a huge international push to have that particular treaty come into force internationally by June 2025 this year. That requires 60 member states to sign on. So far, the African states have been lagging in terms of signing on to this treaty, and South Africa has not done so. We certainly feel that this would add to South Africa's international standing to take the lead in this regard, and also it would align how we engage with the high seas with how we engage with our own territorial waters up to the continental shelf. Going back to sort of the top row there, the regulation of marine pollution that is outside of the treaties. A huge step would be to voluntarily adopt the IMO Marine Noise Pollution Guidelines. It's a guideline document, but it represents international consensus on how to deal with noise generated by shipping. As policies like Operation Pakisa are gradually unfolding, our oceans are becoming noisier, and we don't have anything there as a backstop. And the research around marine mammals, marine birds, it's just growing in terms of the damage we're doing. And that is in turn affecting our ability to use our oceans and to engage with it, whether it's for spiritual reasons, whether it's for economic reasons, whether it's for leisure. An issue that has cropped up for us is offshore ship-to-ship bunkering and oil transfer. It was occurring in Algoa Bay. It was halted due to a SARS investigation, but we understand it has recommenced. This is problematic. There is a reasonable lack of transparency around how this has happened, certainly from the public perspective, but also for those organizations who are sitting in working groups, working with SAMHSA and the TNPA. We have written to the Minister of Transport requesting an investigation into this, and we would also urge you to yourselves ask questions around this practice, why it is happening. It ought to be a stopgap measure while our ports are struggling to refuel vessels portside. We do not understand why it is continuing. We do not understand why it is happening in Algoa Bay. We understand there are less sensitive environments where it could occur if it needs to. And then we need money to be put behind this. That needs motivation around, well, ironically, this is budget day, but we need everybody in government, whatever sphere of government, to make sure that this is not regarded as a nice to have, that it is seen as something essential. We've spoken about environmental mainstreaming, spoke about the Annex 6 to MARPOL having now been signed into our law. The President really needs to make sure that that actually commences, that we can rely on it. And we need to make sure that our transport regulation and legislation takes account of climate realities, as well as the triple threat, which also includes biodiversity degradation. Mainstreaming public participation and community involvement for us is absolutely critical, as is the integration and capitalization of traditional ecological knowledge. We have spoken about that already. We need to also ensure that controls are implemented, and that is where we urge you to exercise your oversight function to ensure that our executive and our administrators are empowered to do this. It is devastating when we have excellent legislation and our administrators come back and tell us that they are underfunded, undercapacitated, understaffed. We know there are excellent people working at organizations like SAMHSA and TNPA, and we need them to be supported. And then we do need to, as Alan spoke about, address community compensation mechanisms, and we will leave it there. And thank you so much for listening to us, Chair.
Thank you very much. I'm really sorry. It's such a fascinating submission, and I think it needs much more time than what we have available today. Thank you very much for your submission. Honourable members, we have some time for clarification on the presentation. So I'd like to request, just in the interest of saving time, being mindful of our time schedule, to keep your questions to clarifying questions, if you don't mind. So we'll start with you, Honourable Breed. Thank you.
Thanks, Chairperson. That's very difficult. I I know some of your colleagues in the Humane Society International and Conservation Action Trust sphere, so this is very important to me. So it's more what I want to find out in terms of Nima and Nemba. You know, we've recently, you know, had gone through the whole process of updating them, and you speak of actually integrating this marine pollution to actually I've lost my English words, pulling through the same language, if I can call it that. With the Animal Welfare Act still being in process, I mean, it's been now, more than 10 years. How is the Animal Welfare Act going to impact this, and how will we then need to look at the Animal Welfare Act, because of course oil pollution impacts that, and specifically with the biodiversity. So I would like to draw on that, and I would leave my questions regarding the Animal Law Project and other things. We can discuss that offline. Thanks, Chair.
Thank you, Chair. So I will be brief. I think one of the challenges that we are facing currently with the animal welfare legislation is that our courts have recognized that animal welfare and biodiversity are interlinked, and that is in our law and our constitutional framework linked to our right to dignity. It sounds a little bit strange, but that's how the courts have sort of got there. So I haven't looked at the latest version of the Animal Welfare Bill, but my sense is that we'll need to again ensure alignment between whatever is existing, because Parliament is presumed to know the law, and that bill. There is difficulty in the fact that we have biodiversity and welfare legislation being very separate. And what I would emphasize is that the most recent amendments to NEMBA included amongst its objectives considering animal well-being. There isn't a definition of well-being. And then Section 9A of that Act empowers the Minister of Environment to give notice in the Gazette if a particular activity is affecting animals' well-being. That hasn't been tested yet, and we're waiting to see how it will be interpreted by that department. But I would imagine that any interpretation of that provision would have to be consonant with the welfare legislation, and insofar as any oil or hazardous substance incident were to affect animal well-being and welfare, that's where it would come in. I'm not sure if it would be relevant to this bill, but it would certainly be relevant to the legislation that domesticates marpole. Thank you.
Thank you. Honorable Nzimande, ladies first. Sorry. Honorable Makasini.
Thanks, Chairperson. Let me welcome the presentation. Indeed, it's very educative, especially to some of us who are coming from inland provinces. Yes, I just want to check, regardless of the challenges and the things that you wanted us to push as this 7 administration at the latter part of your presentation. What happened on the last administration? Is there any stride that you made as the pressure group that you are working on, or your organization, to make sure at least some of the issues are done? Because I'm worried if you said you even lost your membership in the national international community. So I just want to check, why did you lost your seat? What happened? So that when we put pressures, we start where we're supposed to start. We get the background, a little background of what happened, why did you lose our seat, and what pressure must we put as this 7 administration? Thank you.
Thank you, Honorable Makasini. You're welcome to answer. Thank you.
So I'm going to defer why South Africa lost their seat in IMO to the Department of Transport, because they held the seat. But what I will say is that there's a lot of work behind the scenes that is done by many organizations on the ground, many NGOs in partnership with government, with other organizations, to try and cover some of these things. But we are limited by the confines of, we can't force anyone to do it, and we don't have the legal framework to do it. So SANCCOB, for example, responds to oil spills affecting seabirds, and we rescue them. And in some instances, we cover all those costs to care for them, even though we're not supposed to, because when we go to government, we're told there's no money. So we figured out a solution, but it's not ideal. We can't go after the polluter. We can't go and say, you need to pay us. So bringing this into, like, having this legislation come through provides that backing and gives organizations like us much more leverage to take the work forward. That makes sense.
Thank you. Covered. Honourable Nzimande.
No, thanks, Chair, and thank you again for sound presentation. The only thing that one is going to ask, I'll be asking like a novice. Obviously, I'm a novice in the field. I just want to understand what will be the impact of ratifying UN agreement that outside of our national jurisdiction. How will it help us in terms of application? Thank you.
Thank you very much. Please continue.
So the BB&J is a tricky one. So at the moment, we are bound by the obligations of the UN Convention on the Law of the Sea. And the BB&J is actually a protocol to that. And it clarifies the obligations that we actually already have in relation to the high seas. One of the difficulties with UNCLOS itself is it's very old, and it focuses on rights to fish, rights to use the seas, and so on and so forth. And then there's a section that deals with protection of the maritime environment. There's a recent advisory opinion that was issued by the International Tribunal on the Law of the Sea, which is the kind of authoritative body for that treaty. And it made very, very clear that nations have the obligation to protect the marine environment as a whole, pursuant to UNCLOS, and that would include of the high seas, and that it also has an obligation of due diligence, which means that risk assessments need to happen. At the moment, by not being party to something that expressly deals with the high seas, South Africa's hands are behind its back. So it cannot intervene, it can't participate, it can't have a say, it can't make sure that something that happens beyond our continental shelf doesn't affect us. And if you imagine the ocean, it isn't like there's a wall at our continental shelf keeping the international waters out. Also, ships pass from one to the other. So by being party to that treaty, it enables us to connect the dots in a space where, there's always that story about how the map of Africa was sort of divided up with lines. In a way, we're in that situation with the seas at the moment, but it's a very false division. So by being party to that, it gives us, firstly, the mechanism to actually do something, but it also gives us a voice so that we can influence what happens, and we can make sure that things don't happen on the high seas that come back to negatively affect our environment.
Thank you. Honourable Peter?
Thank you, Chair. Just for clarity purposes, Chair, I just want to check about when did this marine oil pollution started or noticed by your department that there's a spillage of oil in our oceans, or there was no act that protects our ocean. There's no act at all. So for many years, this thing has happened. Our plants, our seafood, our livelihood has been affected by this for years and years. That's what now we're picking up now. So thank you, Chair.
Thank you, Honourable Peter. Please go ahead.
Thank you, Chair. So I think that, unfortunately, our colleagues from Transport are going to need to answer that because we are responding to the republication of these things. Certainly from a a sort of civil society perspective, this has long been an issue. You know, as Ms. Stassen has said, there has long been a problem with organizations like SANCCOB just making do, and coastal communities just making do. And in terms of major oil events, the Apollo was, I think, in 1994? 1996. And since then, you know, there's been a ramp up in the kind of sort of expertise of organizations like SANCCOB. There was another sort of push to do so during the Treasure oil spill. So there have been these sort of major events that have pushed civil society to fill the gaps. But in terms of having the actual legislation behind us, we don't know what has taken so long. That unfortunately is something that the department is going to have to answer. I'm sorry. I'm very sorry to our colleagues at Transport.
Yes, Chair, thank you very much. No, I just have one question, Chair. It relates to the compensation of communities. I didn't hear it. I'm sorry, I'm late. I'm never late. So I'm angry with myself. Yes. So enough of the perfectionist thinking. Yeah. But I just wanted to get clarity when you spoke about the compensation of communities. How do you propose that it should be expedited in terms of its current circumstances as it relates to the complaints that you have received from communities now? Thank you.
Please continue. I think it reaches up to the question I want to ask, but it's
Okay, we're going to give a composite question, I think, between four of us. Sorry, this is not because it's that complicated. So the one thing is, I think we need to think carefully about this, because there are the civil liability acts, and we have to make sure that we put this in the right place, and that then the different pieces of legislation fit together. And actually, what my practical suggestion would be that certainly as a Biodiversity Law Centre, we'd be very happy to sit down with the state law advisors and with the law advisors in the department and try and figure out a plan to expedite it from a legislative perspective. But I do think that there's something that can be done practically, and perhaps, I don't know which way I should go. Should I start with, over there?
Just to quickly come to that question, I think most importantly, it's important to give communities an opportunity to add on contingency plans, because that allows them to be able to understand how they would respond if there is a case of an oil spill, which is something that my colleague Ellen actually touched base on, the oil spill that happened in the West Coast. A lot of communities in the West Coast, they have not received any compensation for the oil spill that has happened that side. The only thing that they received was food parcels, which is, for them, it's a local economy that has completely died because of an oil spill that has happened. So if a food parcel it's given to them, how long will it last them as a community? And they are told that they cannot fish for almost 4 to 6 months. So those are the issues that they are facing. So if they are involved in the contingency plans, that means they'll be able to understand how they respond to an oil spill if it happens, and also how they capacitate themselves as communities in terms of which way they address the issues. Another thing is the health impacts. Yeah. Which I think it's something that we haven't really touched base on. How do we ensure that as the committee, which is something I think it's very important, you look into it in terms of how are health impacts addressed in the process? Because if an oil spill happens, then it means that the people that are fishing, they are going to be impacted in the process. So how are all those things incorporated into this legislation? I think I'll just leave it there for Ellen to probably speak to it as well.
So Nina touched on it very well. There is a lot of international law around compensation, but one of South Africa's biggest problems is we've not made that law into national law. And so we can't actually get the compensation in the way that we should. So with the most recent example, what they tend to cover now is cleanup costs, very obvious costs, but not those long-term consequences, the loss of income, the loss of resources, and that OPRC, this sort of bill that we're going through now, closes some of those loopholes through the generation of certain funds and the creation of certain programs such as pollution monitoring, the formalization of the incident management organization, which will allow for much quicker determining of oil spills and catching them when they actually happen and not days later. And then the creation of some sort of fund to help manage some of those things. Now, how that's going to look is where I think some discussion needs to happen and where the big debate lies in how that's going to happen. But I think that has been and will continue to be the biggest stumbling block for South Africa until this becomes national legislation. We even want to take this to court, to take the polluter to court, we'll get hit by the fact that it's not yet national law.
I think that's one of the keys of this whole thing that unlocks the whole thing is funding, and funding will come from the polluter must pay. But how do you make the polluter pay? So I think that's where we are.
Yeah.
And I hope the department will also give their 2 cents worth on how do we make the polluter pay. Which members, Honourable Kaunda, sorry, I didn't see your hand.
Yeah, no, I was outside, Chair. Thank you very much, Chairperson. Let me join the queue to welcome the presentation, which is more informative, and it also highlights our role internationally as a country to be part of the treaties that are able to prevent marine pollution. Firstly, I just want to check if the presenters have analyzed globally where are we seated as a country in terms of marine pollution, because we fully agree with you with the spirit of your presentation that prevention is better than cure, because the livelihood, when it lost, its impacts on society in different ways. I'm raising this because even on climate change, we've been participating in some of the international platforms where we say as Africa we emit 2%, but we need to be active. We do not need to take that for granted that we only emit 2%. It's important that we elevate the work awareness programs. So I heard you raising a concern about participation of African countries. I think there should be more work done to activate that participation. But thirdly, Chair, the last one is whenever there is a challenge, there must be some opportunities where you convert this challenge to an opportunity. Are there any ideas that you have where these communities that are affected can really innovate and be creative to generate income out of the challenge? I know I know that you are talking about the environment, which is sensitive. You don't just get into the sea and or ocean, you do anything that you like, but are there any innovative opportunities that are lying ahead? Thank you.
Thank you, Honourable Kaunda. Would you like to take a bite?
Again, we're going to give a composite answer. So in terms of where...
Don't worry, you're eating into the department's time, so fine.
I'm so sorry. So in terms of analysing where we are in terms of marine pollution, we have dirty waters. We have very dirty waters, and it's a combination of plastics. The plastics treaty is still being negotiated. It is sewage that comes in from different sources. It is the lack of regulation of maritime air emissions. The absence of regulation means that we're kind of like this space with it becomes like the Wild West. You know, if there's no regulation, then people can do what they want to. So we have a problem there, and again, because the seas are interconnected, if you walk along the coastline and you just see after a storm what washes up, from weird deposits to plastics to all sorts of things, you can just see, and that's just at the level of what is visible. It's not the microorganisms, it's not the alien species that have come out of ballast. We do have a problem. And naturally, for those of us in this country who have a spiritual relationship with the ocean, that is also harming the spirit world. It's not just about our how pretty it looks, or our our international tourists who want to go and hang out at the beach. In terms of African countries taking a more active role, yes, we would love to see that. We are mindful that the second part of the Conference of Parties for the Convention on Biodiversity is coming up. I think there's the regional meeting this week, or next week, and then thereafter it's part 2. South Africa, there, as we understand it, is negotiating as part of the Africa group. We would love to see African countries taking a lead, particularly since it's a biodiverse region, and there's a lot of interest still in exploiting African countries and limited ways in which those countries are able to make the polluter pay and get value for what they want. And that is a huge debate all by itself. I'm then going to hand over to Monica, and I'm not sure if Lisa or Alan also want to speak to the creative ideas around community involvement. So we'll go around, I think. It'll just be very quickly, yes.
The department's going to get angry if we're not giving them time to respond.
Sorry, Chair, as they respond, because I want to be specific on oil pollution. Yeah, not general environmental pollution. That's what my question was based on.
Thank you for the clarification. Thank you.
To answer the question around pollution, and to just to add something that is important to consider, is risk. So last year alone, South Africa had 13 marine pollution incidents on our coastline, of which I lost count. Several were oil spills of some form or shape, and 2 of them had a measurable wildlife impact. So when you look at risk and you look at what happens, then this makes sense. It's a no-brainer. We need to get this legislation in place. We take a lot of risk. We have a lot of ships on our coastline, a lot of activity, a lot of interest. We need to protect it so we don't repeat some of the terrible incidents that have happened in the past, whether here or internationally.
I'll probably add to the innovation aspect. We touched on it around the traditional ecological knowledge and the integration of that. So that could potentially be useful in early detection and response strategies. So how communities of fishing practice understand how the ocean current works, where particular vulnerable areas are, that could potentially be utilized in conjunction, in collaboration with agencies and municipal departments to pinpoint vulnerable areas where particular specific species are present, and even just understanding how the oil might move in a particular area. Understanding that and using that traditional knowledge in collaboration with agencies could help respond quicker and deal with the contingencies that are needed in that regard. So that could be a potential innovation option that could be considered.
Just to quickly add on, I think also another potential solution could be opening an emergency fund, and that would mean that all the ships that are coming in would have to pay like a 50% deposit to that fund, which that fund could be used in a case whereby there's emergencies, and that would also address the compensation issue that was raised.
That's a good idea. And they can keep 25% as they go out. Okay, honourable members, thank you very much. I would like to give the department an opportunity. They have to respond to not just the oral submissions, also the written submissions. You have received them in a document. It's about a 34-page document. So department, DG, you're welcome to take over and continue. We have until, so you're going to get exactly the same amount of time as the stakeholders. We're going to give you until, if it's okay with you, until about 11:45, please, if you don't mind. Thank you very much.
Thank you, Honourable Chair and the members.
Sorry, I was going to say Department of Environmental Affairs, not Department of Transport, but I think you know who you are.
Yes, no, that is fine, Chair. And also, thanks to Nina for the presentation. I think we largely agree with her assessment of what is happening in our space. Maybe, Chair, before I hand over to Mr. Nduli to respond on specific oral questions and submissions. I think, Chair, as a country, hasn't been any vacuum in terms of how we deal with pollution at sea. We've got a Merchant Shipping Act of 1951, which largely addresses two main issues. The SOLAS Convention, which is safety of life at sea, that takes a precedence of the work that happens at sea. Secondly, is pollution controls, to make sure that the issues that we are talking about here are well covered. And thirdly, we are the member state of the International Maritime Organization, which we need to conform with MAPOL. As a member state, we've got responsibilities and obligations that we need to abide with, which we welcome, because they also talk to the protection of our environment in our coastlines, as well as the international obligations. And also, I think the issue that has been raised, the lack of coordination and responsiveness when there is an oil pollution in our seas. There are an existing structure for oil pollution and contingency plans, which is coordinated by our own technical entity in the form of South African Maritime Safety Authority. And because there is a capability in the country to detect any pollution that has taken place or is taking place at sea. If the vessel runs into a ground or they are experiencing technical issues at sea, our unit, which is MRCC, will then coordinate, firstly, on the SOLAS Convention side, to make sure that the lives of the seafarers are saved. Immediately after that, we then have to look at if there's any pollution that has taken place, to make sure that we deploy the limited resources. We also work with NGOs when it comes to that, to make sure that our response time is good. But also, Chair, we are a member of the IOPC fund, because there's a difference. There's a pollution that happens on the vessel's bunker fuel. If the vessel was on voyage and it encounters challenges, we need to contain the potential spillage of the vessel that is using to navigate. There's also a protection in the form of IOPC fund that we are a member to as a country, which looks at the compensation for those who have suffered an economic loss following the oil discharge from the tanker. So that is the second part. If the vessel, for example, is carrying fuel, and then for whatever reason it runs into challenges, and then there's a massive spillage, as a country, we can be able to tap into that fund so that we can be able to protect and salvage the damage that happens at sea. So we must always differentiate the two, and we appreciate the view that we need to engage and also include the traditional communities along the coastline in terms of their knowledge of the behavior of the seas, so that as and when we deal with these issues, there's a holistic view and a plan to address as such. So I will then hand over to Mr. Ntuli to respond specifically on the questions that have been raised from the point of submissions as well as the oral submissions. Thank you, Chair.
Proceed.
No, thank you very much.
Sorry, members, you're welcome to follow on your on your handouts if you want to follow this.
Yes. Thank you, Chair. We have prepared in advance the responses to the submissions that were made to the department, but also echoed in today's oral presentations. Not just on oral presentations. I think firstly, it is encouraging that the draft law, which is before you, has attracted the interest that's been displayed here. We have been on this journey with SANCCOB and the biodiversity law since this bill was tabled in Parliament. So during the portfolio committee processes, they were there. Now we're here, they are here. And continuously we are benefiting from this.
I'm sorry, I don't want to interrupt you, but your audibility is not great on this side of the room, so if you can just maybe speak closer to the mic if you don't mind. I think you want to keep your laptop with you, that's why you're staying there, but
Yeah,
just
yes.
keep
Is
close
it
to the
better now?
mic.
Is it better now?
Thank you, sir.
Yeah, thank you very much. No, just to say that we are really grateful to these NGOs for their consistent participation in the process and providing input, which has benefited greatly in improving the bill that we have today. I must as well just brings the comfort to the committee that the department and all its agencies are not acting irresponsibly, exposing the Republic on many risks that face the maritime sector. We can say with certainty that in the event of any major spill covered by the treaties that the Republic is party to, we are covered. I must also equally say that I think for the fact that we are dealing with these pieces of legislation and many others that are en route through this process, it confirms that the maritime law in South Africa is in the development stage. Because having the Principal Act does not therefore mean that then everything is good. We must still go through the regulations that are critical to translating what is in the Principal Act to be implemented and enforced. So, but we are on course in terms of ensuring that the Republic has an effective marine pollution prevention strategy in place. There is a slide that we used in the presentation which showed where we are with that process. And I must just highlight that the bill that we are dealing with today is a very critical element of that. There's been a gap. Not to say that there's not been a way of responding to any major incident. We have been lucky that we have not had a critical major incident along our coast. And this is because of the mechanism that we have in place. The department has a standby tug, which navigates along the coast of South Africa on the west coast and as well as on the eastern seaboard, that detects early dangers or potential casualties. So there's a standby tug which responds to any potential casualty, either to cause that casualty to move away from our coast or to take measures of containing any negative impact that we might have. The assessment shows that we need more than one, but with this mechanism that we have before you, the OPRC bill, we would then be able to raise the required amount of resources that we would provide for an effective protection of the marine environment in terms of equipment, aerial and land, and sea, to ensure that we have an early detection system and we have mitigation measures to in place. So the work that then we're doing is critical and is long overdue, but we are almost there to fulfilling that one. The other bill, treaty that was mentioned related to the ballast water management bill, I must say that watch your post box, is on its way, because I think it has to go to the cabinet, but we have concluded the stakeholder consultations on that bill, and it's going to cabinet in the next couple of weeks. So it's on its way here. The treaty on bunkers is, I think, is being considered by the committee next week. We're grateful for that, for the progress that we are making. So, and the other treaties that were referred to, notably the anti-fouling systems, that is incorporated as far as it is in the present legislation, but also the recent marine pollution amendment bill signed by the president is going to be a game changer in terms of updating us quite rapidly to making sure that we give full effect to the MAPOL Treaty. The Merchant Shipping Act that the DDG referred to is already at the portfolio committee. It's on. I think it will just pass on your. It will come to this committee, but not at the level in which the OPRC bill is being handled, because of where that bill is tagged. Now, very quickly, I'll go through the responses that we are giving to the submissions. I think for those where we are in agreement, I think we're okay. I must repeat what we said in the portfolio committee, in that we are constrained by the provisions of the treaty. So there may be issues that we would love to have in the bill, but because of those constraints of the treaty that we are parties to, we can't. If we have to amend the treaty, we have to go back to the IMO and deal with that. But talking about IMO, I must as well just bring a degree of comfort to the committee that our non-membership of the council does not impact on our ability to participate and inform the convention that IMO regulates. The council's mandate does not extend to the technical issues where all states equally participate openly. So we are not going to be surprised and have things that the council has adopted and we are not, etc. The council looks more on the issues of budget and issues of the strategic plan of the organization, the reports of the technical committees, because all the organs of IMO in themselves are organs, they have full authority and power to decide on matters, and South Africa participates effectively there. But for international status and also contributing in our efforts of ensuring that we are an international maritime center, being on the IMO Council is what we are working on, and is what we are certain that we should, not in a too distant future, return back on the IMO Council and participate there, not for ourselves but also for the sub-region. So I would note those matters where there's an agreement. I'm on page 1 of our responses, where, for instance, on the issue, I think where there's a welcome to the bill, we are excited by that, and I think it should as well send a message to the committee that we are aligned, and that the bill that we are dealing with is a bill that really responds to the real issues on the ground. I'll move very quickly to the submission, particularly dealing with the objects of the bill and the plea from the submitters that the bill must be in line, or the language must be in line with that of the NEMA. Now, we respond by stating that we note this recommendation, however, we consider it unnecessary to repeat in this bill that which is already granted because it's in the law of the Republic, it governs. That's what rules us. The NEMA is there. So we wouldn't want to either rewrite what is in the NEMA into the bill, because the bill's mandate is that of ensuring that the Republic is in a state of preparedness to respond where things have failed, where the prevention strategy has failed. Then we must have ready mechanisms of responding. That's all what we are providing for here in this bill. We as well agree to an extent that the present recommendation on amending 26.4 is possible. I think we can welcome that. And there is a comment on Article 3A of the OPRC bill, where there is an obligation for all that are covered by the bill to have emergency plans in place. And the recommendation from the submitters was that we must also oblige the ships to have a contingency plan. So we are just bringing to the attention of the committee that, whilst noting that, however, we should clarify that this is not an omission per se. On board, all spill control measures are provided in the Marine Pollution Prevention of Pollution by Ships, which obligates ships to have on board SANCCOB, which is the Ship Oil Pollution Emergency Plan. Because the pollution on board the ship can only it has to be contained within the ship such that it does not spill outside. But the ship will not be able to deploy any equipment outside of itself while sailing to prevent the spill from the ship onto the ocean. But it can only contain on board the ship. And there are those control measures which are already provided for in our national legislation of ensuring that ships do have the oil pollution emergency plans on board to deal with on-board pollution. There is also a submission, I think, in relation to Article 8 on issues of research and development. We had considered this as given, and we did not. Whereas, I mean, we don't object to it if there was a particular text that would accommodate issues of research and development, but we had assumed those were given because by having the bill adopted, it adopts the treaty, and the treaty does provide for the need to conduct continuous research and development. Now, there is a proposal under, I think, on the definitions to improve the definition on new development. You know, now this is where the challenge comes, because this submission, I think we interacted with it at the portfolio committee, and provinces are also at the moment going through this very same bill. So the responses that we are giving to this submission are provisional, subject to what is going to come from the provinces in terms of recommendations. But we would, in terms of that definition given there, we would, it's something that we can look into, subject to really understanding as to how the other provinces would be, how provinces would actually promote this, because the new development related to a development that may impact on the oil pollution response mechanisms and equipment and so forth and so forth. It did not refer to the infrastructure development. So there's that issue that needs clarification. But we would note that recommendation. But also on offshore installation, there was a recommendation to make an amendment of that, and we have welcomed these improvements, and we have now proposed the text which is reflected on page 8 there, which should be able to I think accommodate the suggested improvements. I will not go through that in detail. And we then on 5.1, there is a recommendation on the frequency of the national oil marine pollution risk assessments, which are contemplated in 5.1. And in terms of aligning the time frames, I think 1 year, which is what I think we would welcome. So those matters, we can manage them because they don't introduce new provisions in the treaty, but they improve, and member states have powers of ensuring that they provide for those times. 5.2, SANCCOB raised the issue of including ship-to-ship transfer. I think there was a lot of debate on this point at the Portfolio Committee as well. But we are of the view that that is well covered in the present formulation of that paragraph, and we do not think that it is something that's not covered. And we have just extracted the present provision where it refers to any installation or mechanism. So if we take the ship-to-ship transfer as a mechanism, including a subsea pipeline or vessel, so you've got the vessel there, because the ship-to-ship is vessel-to-vessel, and which is used for the transfer of any substance to and from a ship. So I think we think it's very, we don't want to complicate it. It's very simple and clear the way it's currently provided for in the bill. SANCCOB also further, I think, made the submission on cautioning against the danger of being too this is now on risk assessment, that we need to explicitly state what method of risk assessment would be undertaken. The department holds the view that will be too prescriptive. We must make it more interactive, such that those that must conduct a risk assessment must use the best available international best practice on risk assessment without prescribing. Because if we prescribe in legislation, if we write in legislation here, it will mean if that has to change, we have to come back again and say, oh, there's a new development. So we just want to make sure we don't confine and restrict. Then 5.5, we welcome a note, and also on 5.7, we welcome the clarity provided here and accept the proposed change to the clause itself. And on 5.8, the department draws attention to the commentators that this particular expression, no contact with the environment, was included in response to TIPSA, who made representation to the Portfolio Committee. The department wishes, therefore, to retain the clause as in the bill. On 5.9, all primary and secondary legislation are published in Government Gazette. This method is already well established and will be followed in the management of this bill. Any provision which is prescribed will follow the normal process of consultation and publication. You would note that regulations are not something that the minister will just do there's still a process of ensuring consultation. So we do consult in drafting before the minister makes the recommendation. 510, we note this observation, comment, recommendation. Parliament will engage with the DFFE. That is now in aligning the risk assessment and environmental impact assessment with what is provided for in the NEMA. Clause 6 we note, and this point is also standard of all legislation that is published on the website of SAMSA. So this is related to whether the regulations or the National Oil Spill Conservation Plan would be published on the website. Yes, it's going to be. There are established protocols regarding development of primary and secondary legislation and are all underpinned by the principle of participation and consultation. And the regulations in this bill would not escape that. Clause 7, the main advantage here is that there will now be a national oil wildlife contingency plan. That's the objective. It's now going to be there. We have incorporated it in the bill. As to whether it is annexed into the national oil spill contingency plan, I think it's moot because it's going to be there. So you can attach it there. 7.1, the recommendation and reasons advanced are supported by the department. And on 7.5, the intention for the plan to be provided is before commencement of operations, and the reason for this is because the environmental assessment would have been conducted for the project as part of the project approval stages. So we don't want to use this as a means of stopping a project. That would have been undertaken using other legal instrument in place that the proposers would have in their disposal. 8.2, the department notes and welcomes this observation, requires clarity and wish to propose the following possible solution. 8.2 to amend as follows: replace 8.2 with in ecologically sensitive areas with marine protected areas and marine bird and mammal colonies and the assessment of such equipment. Or the other option would be to delete ecologically sensitive areas and insert a standalone clause as follows. All management authorities or persons otherwise in control of marine protected areas and marine bird and mammal colonies must procure or enter into service agreements to operate and maintain oil wildlife equipment. And this is the text that was provided up to the end. So we've got those options that we would consider. 9.1 we welcome, we note and welcome. 9.2 is welcome. 9.2a to B, a recommendation with its reasoning is accepted. And clause 10, recommendations reasoning is accepted. Clause 11, is strictly quarterly is accepted. So there is not going to be like an option of going beyond. So if it's quarter, it's going to be quarter, which I think is okay with us. 12.1, department consider the submission and reasoning valid and agrees to it. 13.8, the department agrees with the clause with the use of words oil pollution incident in 13A. So we welcome that as an improvement. And in 13A, we consider this suggestion and clarification unnecessary. The FE sits in incident management organization, which is proposed by the bill, and there is open sharing of information and coordination between ourselves as part of the obligation we have to cooperate. This clarity is also unnecessary in clause 13 and as is well managed through intergovernmental coordination between departments and through the institution to be established by the bill. The observation is also noted, which refers to the alignment with NEMA there. 13B, the department considers this to be too prescriptive to the powers of the minister. In the convention, it is reflected as may, and we have aligned with the spirit of the convention. And that's the language that I think is used in all our legislation. 14.4, 1 to 4, we welcome this suggestion and the reasoning behind it, and the department welcome the insertion of a time frame, which we which improves the provision. 15.1, we will welcome the proposed amendment. 15.2, OPRC fund is to cover expenses associated with the response and not compensation, because we don't know how much is going to be raised there. But as the DDG explained, compensation is already provided for in this international insurance that South Africa is party of, which is oil pollution compensation fund, which again has got parameters as to what can be covered. But in terms of the cost, which was raised in 15.2, the OPRC fund would cover all preparations to respond as per the bill. Moving quickly, 15.5. 15.5, our response is that it includes financial decision making within the PFNA prescripts. This is now the incident commander in terms of the powers he has to spend the money in ensuring that there is a response, an effective response. 17, the department will come the inclusion of ecological assessment. This is very welcome. This recommendation, it strengthens and make the bill much clearer and stronger, governed by the principle of ecological assessment as one of the grounds of termination of an incident response. The recommendation proposing prescribing follow-up action, including monitoring and reporting, is fully supported. 18.2, response costs will be financed by the OPRC fund, as I've stated. 22.3, South African courts already have jurisdiction over maritime disputes and claims, so they will be able to enforce. And South Africa, I've shared this before, that we are considered to be the ship arrest capital of the world. You can't escape us. So if the ship that is polluted has run away, any ship associated with the polluter will be arrested, and they get arrested, and we are able to recover the money. 30.1, that submission will present drafting of clause 7.4 has such a possibility, which in principle is correct. However, consideration for amending the included time frame is required. The department would recommend that it is extended to 90 days. 30.3 to 5, the department confirms that the structure of this part is in line with other maritime legislation concerning how offences and fines are handled. We therefore do not have concerns regarding the present provisions in 30.3 and 30.5. 31A, the department agrees with the inclusion of the following clause requiring regulations 5.6 and 5.11 and 13B. The department prefers the using May instead of March. 33.1, noted, but we disagree with that comment. I think that very quickly deals with the comments, which I'm sure that the submitters will be, the committee will be, would notice that this has been a journey. We are now here, and I think we are finding each other well, and we continue on the journey. And I think I hand over to the DDG if he has some remarks.
Thank you very much, DDG.
No, thanks. Thanks, Chair, and thanks, Mr. Nduli. And I think our submission, Chair, ends there. Thank you very much for the opportunity.
Thank you very much for that from the department. I think, honourable members, before I hand over to you, if there's any questions for clarification, the amount of submissions that the department has agreed with shows the quality of the submission from our stakeholders, and I'd like to thank you for that. Very well considered submissions, and it's very clear from the department's response on most of them that they are highly appreciative of your submissions. So thank you for that. Honourable members, anybody want to ask anything for clarification? Ooh, lots of hands there. Okay, let's start with Honourable Treza.
No, thank you very much, DGG, and thank you very much to Mr. Nduli for a for a cogent clarification of these matters as it pertains to the submissions from the stakeholders. Sendula, I heard you talking about preventive measures. You know, the primary tools used to respond to oil spills are mechanical containment, recovery and cleanup equipment. And so you spoke about the preemptive measures that you have in place to curtail that situation in which you could find yourselves having an oil spill. So therefore, I just want you to take us through the nature of that entire dispensation of preemptive measures, where's that, and the effectiveness in the current state. Because I also heard you talking about the need for the funds. So I just want you to take us through the dispensation so that we see where the funds are needed. The second one is pertaining to the fact that the Eastern Cape currently is facing issues of extortion, right? Such that gangs now, they have been they are sophisticated in such a way that they collude with police. They've actually neutralized the police, and they are in collusion with some of the high profile politicians. How do you make sure that you put measures in place preemptively to ensure that the situation that we see in the West African seas, between West African seas and Italy, of parading an extortion does not happen in our seas? How is the department ensuring that this bill has created much awareness for the outsiders that are coming, that could be the ones that you are saying that you are looking at preemptively to anticipate whether there will be casualties? Are they aware of the bill, and how so?
Thank you, Honourable.
Thank you very much.
Thank you very. As you conclude, thank you very much, Honourable Keza. I think the department will respond to that question, and then we'll take the next question. Thank you very much.
No, thank you, Honourable Chair and the member for asking the question. Just to, in terms of the state of deterrence that we have, I've referred to us having a standby tug, which the department has contracted, stationed along the coast of South Africa. So that standby tug is there to respond in case there is a vessel that is facing difficulty along our waters or destined for our waters. So there is a system of communication between us and our neighboring countries in the event of a ship that is heading our coast, for us to be aware and be ready to respond. So we have responded to a number of near casualties, and that vessel originally, it's only one at the moment, but the assessment that was done prior as part of the development of the bill was that revealed that you needed about 2 vessels to patrol the eastern seaboard and as well as the western seaboard. This is not to say that one is not doing the work at the present, but because it is also supported by the tax from the managed by the National Ports Authority. So in terms of the other equipment, for instance, what you would see that the amendments that we are proposing in the bill, for instance, now gives power to SANCCOB to own vessels and as well as other surveillance equipment. So surveillance equipment would then give us the capacity of having an early warning far much more distant, and also to monitor what is called oil slicks, which is among small drops that ships may be shedding without us being aware, just to monitor that. So it's that equipment that would be additional. Now, in terms of maintaining the one tag that we have, the resources that we have are constrained. But with having a dedicated fund on preparedness and response, and remember that the sourcing of the fund is on the polluter pays, potential polluter pays principle, in that the contributors to the fund are those that handle the product that we want to respond to in case there's a spill. On the issue of the piracy, how are we planning for that? We also are working with the Department of Defense. We've got a standby vessel patrolling the Mozambique Channel to deter any act of piracy coming on the east coast, particularly from the Somalia area. We are members of the Djibouti Code of Conduct and the Jeddah Amendment, which is a mechanism that states through IMO have established to cooperate on tracking the unlawful activities out at sea, not only pirates but all other unlawful activities. So I think, or in terms of raising awareness, yes, I think using public platforms, there is a greater awareness that South Africa has just adopted. The President has just signed the Marine Pollution Amendment Bill, and as well as that this bill is under consideration. So there is readiness, and the responses are part of that awareness that is already there.
Thank you very much. Honourable Preza, are you covered?
I'm not covered.
Okay, but we run out of time, so let's pretend. Honourable Makasini.
No, Chairperson, I just want to check on the issue of public awareness. The submission that is here on the bill is only majority is coming from the NGOs. We don't see the submission made of the traditional leaders because they have to form part of the stakeholders. So I want to check how are you involving the traditional leaders in the continent generally to avoid the issue of Paris and everything for the future. Because if you are not involving abantu bomhlaba, then which means one day we are going to challenge this threat. So I want to check the involvement of our traditional leaders and the two threats that you say they are coming from the cabinet. Which are those threats that we are talking about? Because they are coming, they're on our post office next to the cabinet, but you didn't tell us which are those threats that will come into the cabinet very soon.
Thank you, Honourable Makasini. I suspect the province has still got to do their inputs, but I'll let the department answer. Thank you very much.
Yes. I think in terms of participation of traditional authorities, that's what is currently going on with the provincial consultations. So we have, for those where we have attended, that question is the first issue that's being addressed, and they checked, and we have observed the excellencies, the royal participation in the provinces where we have been. Although I think in terms of the taking of the bill, I think it's just going to be through those consultations where we would. And then the other question relates to...
Honourable Makasini, do you want to just clarify your second question that you asked? The treaties.
Oh yes, it's the ballast water management bill. Yeah, the ballast water management bill is going through the cabinet process. So it should be, we are targeting that it is presented in
Thank you. Thank you very much. Honourable Peter.
Thank you, Chair. I should think, Chair, the reason why these departments are here, they are seeking solutions of this bill. I don't want to dwell too much, but let us focus to this bill. Our ocean are affected now, since yesterday, since years ago. Millions of people are eating food from that sea, who are depending on that sea. Any disease because of these oil spillages, it's affecting the entire nation. What do we do? My take is, what measures do you have in your mind as a department to put in place to stop these oil spillages? Because I know you need a piece of legislation to be added to what is maybe is ineffective, because surely there's an act that protect our oceans from this oil pollution. You are here for solution. Now I'm saying our people are dying now. What do you have in place as a department? Thank you.
Thank you, Honourable Peter. The department is welcome to respond to that.
Pollution by ships in South Africa is unlawful.
Huh?
Yes. By ships in South Africa is unlawful, and it is enforced. Now, pollution of the ocean does not come from ships only.
Yes.
There is inland pollution of the ocean, which comes in the form of oil and other problems. Okay, and that is, well, government in its totality has to make sure that it has measures that prevent the pollution of the ocean, and we have those measures. And those measures include, for instance, which I think the submitters have made reference of, that is the particularly sensitive sea areas. We even have areas where we have protected that are either populated by the marine mammals that are there, that should not be, that should have extra protective measures. And we do have those extra protective measures.
Okay.
So to make a statement that we have our oceans exposed and there are no mechanism of preventing that, I think is devoid of any real reality. There's a need to improve enforcement, but in terms of taking a zero tolerance on marine pollution in South Africa, it exists, and we continue enforcing and ensuring. The risk, for instance, that's been identified of Alcoa Bay, there is stakeholder participation there, and there are assessments that the authorities are conducting and supposed to conduct to mitigate any risk on the environment. So this bill, what it does, it makes us to be combat ready, because the international community identified that if we're a coastal state, we need to have an oil pollution preparedness and response. But you must fund it yourself. You must do it yourself. So this treaty is being now domesticated so that we have that mechanism of being ready by ensuring that people who handle oil have got, they do their own risk assessment, and that they procure equipment that they would need to respond to any spill of oil, that there is a national oil pollution contingency plan. If I could just share with the chairperson in the committee that we currently have the national oil spill contingency plan, which is in place, but awaiting the bill. It is in place. All the stakeholders that we have provided for in the bill, we already have people that are working in anticipation that their work would now be well regulated. So those mechanisms, because remember that the ocean space is 2 times the land space. There is Dr. Deacon, I hope he's still alive, he wrote a thesis which suggested that the ocean is can become the 10th province of South Africa. And that's the importance we are attaching to the marine environment. And we don't, there's no playing out there. We do all we can, but the coast is too wide. The biodiversity high seas treaty is new, but it's a treaty that we are looking into. I'm sure our, as government in totality, the Department of Environmental Affairs helps us on that part. But in turn, we are parties to the present convention on the high seas. That's why we are able to intervene on the high seas in case there are issues. So this bill gives us that power and the resources that we need to patrol this vast area. It's too vast. I mean, the opportunities that are out there, they are so, you can't even see. It's very far. So there's a lot, but we are, within the means that we have, are protecting the Republic and ensuring that we are ready. And then that's why I think working with the NGOs helps us ensure that we strengthen the regulation that we have in place. Thank you very much.
I was going to give Honourable Treza another bite at the cherry because he needs clarification, but Honourable Nzimande has now put up his hand, so sorry, you're at the back of the queue. We've got 5 minutes left. Honourable Nzimande.
No, thanks, Chair. Pele, sisezweni labantu. Let me ride on the question that was asked. What's the rationale to only involve traditional authorities or leaders at the level of the province and not involve them at the national level as traditional house of traditional leaders, house of traditional leaders at the national level? Why choose only to involve them at the provincial level?
I think I'm looking across to my legal advisors because in their,
Playing rugby now. Pass the ball.
Yeah, I think they need to help us because they gave us some guidance here.
You're welcome.
We were advised, so that.
You're going to earn your lunch now. Let's go. Like lawyers, do you want to respond in writing?
No, Chairperson, if I may assist quickly.
Thank you.
Chairperson, when the tagging processes are done, that is the issue that is also looked at. And in the context of the bill and the provisions that it seeks to address, it is not necessarily an issue that pertains to customary matters as required in terms of the Traditional and Khoisan Act that has been rejected. But if we revert back to the older act that was in place in terms of Section 18, the current bill does not fall within that context, that it should be sent directly to the National House of Traditional Leaders. But submissions, if they come directly from them, they can be accepted and addressed through the same processes as any other stakeholder, Chair.
That made sense to me. Does it make sense to you, Honourable Nzimande?
No, it doesn't. Definitely doesn't. Probably, you must rethink how you engage with traditional leaders. I don't believe it's an honest way of dealing with them and make them subordinate of everything. That can never be accepted by us.
Noted. Honourable Treza, if you want to make a quick question, then you can do it.
A quick
for
question,
clarification, but not a quick speech.
Oh, great. How many?
You have 1 minute.
He knows that. 1 minute, okay.
You are eating into your own lunchtime now.
Yes. Yep. I wanted to ask the legal team, maybe they can help me, I saw in the presentation the principle of cooperative governance as the first principle there, and then section 5 of section 10 of subsection 5 talks about who will be facilitating the courses of the disaster management for the panel. So in light of the fact that the disaster management is under the custodianship of DCOP, who will actually be facilitating that for the panel? And the second question could be that within 6 months of this act coming into effect, the minister would appoint from within the staff authority a panel of competent people. Please take me through, because when I went through it last night, take me to the criteria within which the minister will use to appoint a panel, and so that I do not get tempted to view it as a subjective and the space in which he can use bias to that process. Thank you. Thank you, Chair.
Thank you. Who did you ask the question to? The legal advisors. Okay.
Chairperson, we don't want to steal your thunder, because when we were invited here, we were told that there'll be two stakeholders will be in front of you. One, civil society, and two, the department. So today it's not our day, Chairperson. We'll be stealing your thunder. But we'll deal with it, Chairperson, when we come back. We'll speak with the Community Secretariat for programming, and then when we come back, when it's our time, we'll attend to those questions.
So what their answer to you is they want to come back prepared. So they should become politicians. Okay. So thank you very much, honourable members. I really appreciate your time and your considerations of your inputs. I would like to just quickly give Ntalini an opportunity to explain the passage of the bill from here on, so that everybody is on the same page. And I would like to give our stakeholders representative just another opportunity to just make a closing remark if she wants to. And then I'll make my closing remarks, and we'll adopt the minutes of the previous meeting, and then we'll make closing remarks. Thank you very much.
Thank you, Chairperson. I'll be very quick. There's processes in processing this bill, as we are aware that this is Section 76 bill, and is the bill that lapsed in 2022. I mean, from the previous, Parliament, and it has been revived. And when it was revived, there was a deadline of 10 September, so that this bill at least can be completed. Then, we couldn't, meet that deadline. Then we have to write for request for an extension, that we couldn't meet that deadline. But in terms of the processes, we had our briefing by the department last year in October. That was 9 October. Then we scheduled, provincial briefings. Same in October, but majority of provinces, they couldn't, do their provincial briefings in October, and currently most provinces are still busy with the provincial briefings. So we also then allocated that, the month of January to March, then provinces then will be, we'll be doing with, provincial public hearings. And most of the provinces, they are behind, they haven't even started. So we said that we are going to have our meeting on the negotiating mandate on 9 April and final mandate on 16 April, which I don't think we are going to make it. Then we will have to now write another letter of extension, so that we process, because we are not going to, when we look at how the provinces are moving now, they're not going to meet this time frame. So we are likely to change the program after writing the request for an extension. So that's how far we are with the processes, Chairperson.
Thank you, Mr. Mutulini. This bill will be done this year.
Yes.
I think the provinces are also doing their SOPAs for the next 2 weeks, and then they're going to start doing their public participation process again directly after that. Thank you very much, honourable members. Can we adopt our minutes of our previous meeting quickly? Just a bit of homework. They've been circulated to all of you. It's the minutes of the Select Committee on Public Infrastructure and Minister in the Presidency of the 4th of December, which was held on a virtual platform at 10 o'clock. The agenda items, there were 4. It was written submissions on the marine oil pollution bill, the oversight, consideration of our oversight that we did to KwaZulu-Natal, the previous minutes of the previous meeting, and then our draft first term framework that was circulated as well. Any problems on page 1? Any problems on page 2? Thank you. Any problems on page 3? Honourable Kaunda.
Thank you, Chair. I think we need to reconfigure 3.3 because we can't start with the second. We must start with the mover and the second follows. So I seconded and the Honourable Skid Kohel moved. So it's the other way around. Yes.
Okay, that's duly
So
noted.
don't be shocked about the term reconfiguration. I know there are many reconfigurations in the country.
Left brain, right brain. We'll fix that. Okay. It's like my wife says, I've got a split personality. Okay. That's duly noted. We'll change that. Is there anything else? Thank you very much. Can we have a proposal for those minutes, please? Thank you, Honourable Breed, seconder. Thank you, Honourable Peter. Those minutes are then duly adopted. Honourable members, thank you very much. I'd like to give our stakeholders, it takes so much time and effort to get to Parliament, and I'm so sorry that we didn't have enough time today, but I'd like to give you a chance to just make closing remarks if you want to from your side. Thank you.
Thank you so much, Chair. We really do thank you for your attention, and we are so encouraged by your questions, by your interest, by inviting us to come here today. Certainly as a organisation that usually sits in the environmental space, it is such a pleasure to be able to actually address people engaged with things that we think are really critical if we are going to actually mainstream these concerns and bring everything together. So thank you so much for that. We are also very encouraged by the responses of our colleagues at the Department of Transport, and we really do hope that we can build a productive dialogue. We already have spaces where we're working with you, and our representatives are working with some of your organisations, and we would love to carry that forward. We also really would love to, if you could let us know the details of the provincial consultation so that the community constituencies that we are in touch with can participate directly and not just rely on us. And if you have any queries for us, those are the emails of our reps here, and we'll also be around to chat to you as well, and so will Liz, Chris, and Andres, of course. And Andres, we're very glad that you were able to accommodate him so he can see how this all works and let his home community know that you are interested and representing community interests as well as those of traditional communities. So thank you very much for that, Chair.
Thank you indeed. Thank you very much. Colleagues, as we conclude then today, I'd like to extend my sincere appreciation to all of those who contributed to this crucial discussion today. I think your insights, your expertise, and your commitment to safeguarding the marine environment in South Africa is invaluable. Both stakeholders and the department and our members in Parliament that has oversight. The presentations and submissions we heard today reaffirm, I think, the urgency of strengthening South Africa's legislative framework for marine oil pollution prevention and response. We recognize that marine pollution is not only an ecological disaster but also a socio-economic crisis, one that directly impacts the livelihoods, the food security, biodiversity, and our nation's international standing. Through today's engagement, we've gained critical perspectives from the Biodiversity Law Centre, from SANCCOB, from BirdLife South Africa, the Green Connection, and Natural Justice. We've highlighted some key areas requiring attention, including the integration of international best practices, enhanced public participation, strengthened enforcement mechanisms, and capacity building for response efforts. We've also heard from the department in their response to the submissions, and we appreciate their commitment to ensuring clear implementation mechanisms, alignment with existing environmental legislation, and addressing concerns raised by our stakeholders. The ongoing work to refine this bill must ensure that it's practical, enforceable, and adequately resourced to fulfill its objectives effectively. As this committee continues its oversight role, we will remain vigilant in monitoring the implementation of the bill once it's enacted. We must ensure that the necessary regulations are promulgated without delay, that relevant authorities, including the South African Maritime Safety Authority, are empowered and funded appropriately, and that all stakeholders, especially coastal communities and small-scale fishers, are actively engaged in decision-making and response efforts. I want to commend all participants for their constructive engagement and reaffirm this committee's commitment to seeing this process through to a successful conclusion this year, one that reflects our constitutional obligations to environmental protection and sustainable development. So with that, I'd like to declare this meeting officially closed. Let us keep on working together to build a cleaner, safer, and more resilient marine environment for all our generations to come. Thank you very much.